It's 2025 and a new year means brand new opportunities. And for a lot of you out there, I know you've been thinking about one thing over the holidays, and that is starting your own business. But you have so many questions like how do I get started? How do I come up with a brand? How do I even sell stuff to people? And what am I even going to sell? Now take a deep breath. Shopify has got you. Shopify makes it simple to create your brand, open for business, and get your first sale. And you can get your store up and running easily with thousands of customizable templates. You don't have to be a coding nerd or a design geek to get this done. All you need to do is drag and drop. Shopify also helps with the details like shipping, taxes, and payments from one single dashboard, so you can focus on the important stuff, like growing your business. Established in 2025 has a nice ring to it, doesn't it? Sign up for your $1 per month trial period at shopify.com/truecrime, all lowercase. Go to shopify.com/truecrime to start selling with Shopify today. Shopify.com/truecrime.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my founding co-host, Brett.
Oh, Alice, that was smooth. That was beautiful. I love it. Founding co-host. You're also a founding co-host. We're founding co-hosts together.
It was not smooth at all, Brett. I could not get the words out of my mouth. And did you understand what I meant by founding? Y'all, it was a pun to the founding fathers. And what the heck did they mean when they had both a national government and states? How can you have two sovereigns in one? And how would they not just fight each other? So that was my pun. If you didn't get it, it's probably because I'm not making very much sense these days.
Whatever, Alice. We love working moms here on the Prosecutors, especially working mom Alice. And she's killing it, guys.
Woo.
She's killing it.
It's killing me, y'all. It is killing me. You're just going to have to wait till
I
the
hope everybody
bloopers
appreciates
to figure out what was going on.
I hope everybody appreciates Alice and the effort that she continues to put in to put this show out and our other podcast out, even as she's got a new baby. I tell you what, I got 2 kids. I have no idea how Alice is doing it with 3, but
Not well.
About you, Alice. About you. But Alice is right. We are talking today about a question that we get as much as anything, this balance between the federal system and the state system. And we get people ask us all the time, how do you decide what you're going to prosecute? Whether the state's going to prosecute, the federal government's going to prosecute. What does that even mean? How do they work together? Do they fight all the time? Which is, yes, they do. And where does all this come from? And I know probably those of you overseas have even more questions about how all this works, because the United States is so unique in so many ways about the way the government works. And that's not just American exceptionalism talking over here. There are very few countries in the world that have a government like the United States has, but we have it, and it goes all the way back to the founding of the country. And because of that sort of long history influences the way we do things today. And we talked about this before, this whole idea of a sovereign within a sovereign, this notion of federalism, this notion of states are sort of independent and then there's federal government. And it goes all the way back to the Declaration of Independence. If you've ever read the Declaration of Independence, at the end, it says that these colonies of right ought to be free and independent states. And so the idea is not a country. These colonies should be a country together. It's that they are free and independent in of themselves. So you had the state of Massachusetts and the state of New York and the state of Virginia, and they were all very different, and they basically were sovereigns unto themselves. And they declared independence from Great Britain. They fought a war. They won the war. What a lot of people don't know is we didn't go straight from winning the war against Great Britain to now we have the United States. There was this interim period where you had something called the Articles of Confederation, where basically these states tried to stay basically independent and sort of alive, maybe in the way of the European Union today, where they very much were independent states. They had their own monies. They had their own state religions. They had their own laws. They had their own debt. They did everything sort of on their own. They had their own militaries. And it wasn't long before that fell apart. And once it fell apart, then you had the Constitution. And the Constitution tried to basically create a system where, yes, the states were still independent, but there would be a national government that had certain very narrow powers and very narrow jobs.
And you can imagine why this was so, right? We had just come from fighting a war with Great Britain where there was one sovereign, the king. And here the states were kind of very shy of having one centralized power. And that's why there were these independent states and they didn't want to take on each other's debts. Virginia had their economy. They had very fertile soil. They could plant all sorts of crops, whereas Massachusetts was much too cold to be able to grow all these crops. And so there was kind of this rivalry among the states, and they were very jealous of their own land, of their own people, of their own way of life, because they knew what it was like when power was too centralized. But there is a reason why there had been centralized power in Great Britain and why they were one of the great superpowers in all of history, right? It's that individual small little states or countries don't have enough resources to really flourish in the grand global scheme. And that's why these states actually needed each other, even though they were wary of this one centralized power.
And initially, the thought really was, we're only going to give you centralized power over things that you need, that you have to have. So what's one of our problems? Well, the debt's an issue. Well, we can't deal with all these people having different debts, and we can't deal with all these people having different money. So basically, the federal government says, okay, we're going to take all the debt. We're going to be the ones who print the money. So it's going to be our money now. You're not going to have New York bills and Virginia bills. We're going to deal with things like trade and commerce. So we're not going to have New York putting tariffs on Virginia's goods. We're going to have a one national sort of tariff system and that sort of thing. The criminal law was very, very small. It was things that had to do with these sort of big national ideas. So if you're committing some sort of national crime, treason, something like that, we'll have a criminal law to cover that. But the vast majority of crimes are going to be handled by the states. And states very much remained independent. A lot of you know about the Bill of Rights, you know about, freedom of religion and freedom of speech and the Second Amendment and all that stuff. Well, at that time, that all applied to the federal government. So the federal government couldn't pass a law about establishing a religion, but the states could, and the states did. And states had their own established religions. So like Maryland might have Catholicism, and Virginia might have Episcopalianism, right? And it was that sort of thing. That eventually fell away, but they could do that under the original Constitution.
And so you can see that the federal government was meant to be kind of a gap filler, but really was not the way of life for these states. And all of these protections were against the federal government because of that skepticism towards that one centralized power. But people love their individual states, so they didn't need those particular protections from their state because it was localized, right? You knew the people who were ruling you from your state. They were literally your neighbors, whereas you may not know what was happening in New York, and they may be part of the federal government. So you need to have protections against people you didn't know. And that was kind of the idea of why these protections only applied against the federal government and not the states when they were first adopted.
And there was this feeling of laboratories of democracy where you'd have different states do different things and see how it worked out. And if Virginia wanted to have an established religion and you didn't like that, well, you could move to South Carolina, right? And that would sort of show Virginia the error of their ways. Virginia, in reality, had a constitution that was very protective of individual liberty. Thomas Jefferson was a big sort of proponent of this. And so in a lot of ways, Virginia was a place where if you wanted freedom of religion, you could go there. If you wanted to get away from sort of Massachusetts and all of their sort of, more strict religious whatever, you could just move to Virginia. And there was this notion of how that's how it's going to work. Federal government's going to be very narrow. It's going to have very limited powers. We're all afraid of the federal government. We're not afraid of the states. As Alice said, very local. Your state reps. You're not worried about some distant power. They're just down the road. It's all going to be fine. We're going to let the states do basically whatever they want. And that lasted until about the Civil War. And that's when everything changed. And in many ways, the Civil War is sort of a second founding. So one problem that you had built into the system was slavery. when the Constitution was ratified, by that time, most of the states north of the Mason-Dixon line, which is the border between Pennsylvania and Maryland, had essentially gotten rid of slavery. They hadn't entirely. There were still some slaves in those states, but they had moved away from slavery. It wasn't economically feasible in those states. As Alice said, places like Massachusetts, you're not going to have huge farming. Agriculture was not going to be your main thing. And so they had depended less and less on slavery. In the South, where the soil was fertile, the growing season was long, they became more and more dependent on agriculture. And as they became more and more dependent on agriculture, they became more and more dependent on slavery. And the Constitution had built into, on a compromise, basically, that slaves, so Southern states wanted a slave to count as one person for the purposes of representation in Congress and representation in presidential voting. The Northern states were like, what are you talking about? They're slaves. They shouldn't count at all. You can't have enslaved people and then say, but they should count for the purposes of our elections. And so there was a compromise, a 3/5 compromise, where every slave would count as 3/5 of a person for the purposes of voting. Well, eventually, you got to a point where the South was winning a lot of elections based not so much on its actual population, but based on that. And this caused more and more friction. You had the Republican Party, which was a free soil party that very much believed in the abolition of slavery. It started to grow up, and by 1860, the Republican Party was in a position where it could win the election. And the Southern states, obviously, none of them voted for Lincoln. The Northern states, all of them voted for Lincoln. Lincoln won, and at that point, the Southern states knew that it was over, that basically slavery was eventually going to die. There was no way that you could continue this. The Republicans and the free staters and the abolitionists were going to continue to grow into power. The Southern states really wanted to expand slavery. They wanted to conquer Cuba and expand slavery into Cuba. They wanted slavery going off into the West. They wanted to conquer Mexico. That's what they wanted to do. And they knew that was never going to happen. So eventually the South secedes from the Union. There's a big war. It's a civil war. Read all about it online. At the end of the day, the Union wins. And at this point, the Southern states, which had seceded, are now brought back into the Union, but there's a price. They have to agree to something called the 14th Amendment. And the 14th Amendment says, hey, all that stuff that used to just apply to the federal government, now it applies to the states as well. And the federal government is now much bigger and much more powerful and starts to take more and more of an active role in things like criminal law. So you went from a situation where the states were the ones who did the vast majority of criminal law to where now you're going to have a bigger and bigger federal legal structure as well. Nevertheless, there's still a division between them, and it remains to this day.
And you can imagine why now we swing the other way, right? We had swung from being very skeptical of the big centralized sovereign, the king in Great Britain, to, okay, we're all individual states and individual sovereigns, and the big bad federal government is not big. It is very, very limited, very small. But then when you see that obviously these states needed each other. They needed each other for war times with the rest of the world. They needed each other for debt. They need each other for the economy to really function at all. And if they were so decentralized that it could lead to something like the Civil War, another civil war may have completely torn apart these individual states, this country, and we could not sustain another hit like that, which is why the federal government became larger, bigger, and more powerful out of necessity, because everyone saw what could have happened in the Civil War. I mean, truly, if the Civil War came out a different way, we would be in a very, very different situation today. So what does the 14th Amendment say? You should go read it. It is now in our Constitution, but it was an amendment that essentially Section 1, you've probably all heard this. It starts with all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. And so obviously this goes directly to one of the biggest divisions during the Civil War, which is slavery. And now with kind of the advent of the 14th Amendment, with the 14th Amendment, remember we talked about the Bill of Rights before. The Bill of Rights, freedom of speech, freedom of religion, all of those things, freedom to right to bear arms. These Bill of Rights only applied against the federal government. But now, because we had seen the division among the states and how different they viewed different rights, the 14th Amendment began to incorporate the Bill of Rights against the states. Not against, but the states then had to also guarantee these rights to each other, because then you wouldn't have, say, Massachusetts discriminating against someone from Virginia discriminating against someone from New York, etc. We needed to find a way that we could essentially function as an entire country, as one. Otherwise, we would tear each other apart yet again.
And this whole period is fascinating. I mean, we could do, and should do, an entire episode. We should do an episode on Dred Scott, which the 14th Amendment directly repudiates, or an entire episode on the Reconstruction period, how all this worked out, the fact that the Supreme Court, for a really long time, basically acted like the 14th Amendment didn't exist. I mean, the 14th Amendment very clearly was intended to apply the Bill of Rights against the states. And when the cases first came up in the Supreme Court was like, nah, we're not going to do that. It just ignored it. And there were these cases called the Slaughterhouse cases, which are just completely wrong, where the Supreme Court was like, nah, we're not going to do that. And basically, it took another 100 years where the Supreme Court did this thing called incorporation, which they just completely made up, where they just slowly incorporated the Bill of Rights against the states, slowly but surely. For instance, we talked about grand juries. They've never incorporated grand juries against the states. And that's why you don't have to have a grand jury in the states, because the grand jury provision of the Bill of Rights only applies to the federal government. It should apply against the states, because the 14th Amendment clearly intended it to. But we didn't get there. That's a whole nother episode. You have the situation where now the federal government is really starting to impose its power, but there's still this basic division. The federal government is still a government of limited power. It may not seem like it, especially today, but it is. It is a limited, enumerated powers. That's the only powers the federal government has, is enumerated powers. The states have general powers. The state has something called police powers. The state, basically, anything that there's not something that says it can't do, it can do. So that's the state. If you don't say the state can't do it, it can do it. The federal government is the opposite of that. The only thing the federal government is supposed to be able to do is what you say it can do. So if you don't say the federal government can do it, it can't do it. The states have general power that's only limited by these restrictions. The federal government has limited power that's expressly granted. That's the way it's supposed to work. So you have these sort of two spheres of power. And that's why, the states have every crime you could imagine, there's a state crime for it. From murder on down to jaywalking. There's no federal jaywalking crime. There's no federal DUI crime. There's very limited federal murder crimes. And that's because of this sort of general versus limited powers. Now, having said all that, you probably know the federal government criminalizes a whole lot of things. How are they able to do that? Well, that's where the commerce power comes in. So the Commerce Clause is this clause that gives the federal government the exclusive right to regulate commerce. So basically, the idea was, like I said, we don't want states throwing up all these barriers to trade. So the federal government, they get to regulate commerce. And the idea is, while regulating commerce, part of that is criminalizing things. So what the federal government has done is put a commerce hook into everything. So what you'll see when you see a crime is something happened. Take wire fraud. The use of the wires in and affecting interstate commerce. And so the idea is, if the wire crosses state lines, or even doesn't necessarily cross state lines, but operates on an interstate system, then that becomes a federal crime. There's a federal jurisdictional hook through the commerce power, and that's where a lot of these federal crimes come from.
And you might think, wow, that seems like kind of the federal government is able to then swallow a lot of the state police power. And you're kind of right about that. Over time, through the commerce power, the federal government has been able to take on more and more. Take, for example, felon in possession of a firearm. Think about someone who is literally holding a gun who should not be holding it. That seems squarely within state powers, right? That person is possessing a gun sitting in one place. Unless they're somehow standing between state lines in two states, it's really hard to imagine how that person could be affecting the Commerce Clause. Well, you'll notice that one of the elements of felon in possession of a firearm for the federal statute quite literally says that the gun has traveled in interstate commerce. So you see how it's kind of attenuated, right? The person doesn't even have to travel across state lines to get the gun. The person doesn't have to travel across state lines with the gun. The gun that they're actually holding while standing in one state, as long as it somehow traveled across state lines, is enough for the federal government to be able to step in and prosecute that sort of crime. So with that sort of kind of broad definition, you can see how almost any state crime can then be hooked into the federal power. So you're probably thinking, whoa, if there is now so much overlap between what the federal government claims touches commerce and therefore can regulate, and also what originally the state was meant to have general jurisdiction, general police power, then how do we decide who prosecutes what? And that is a great question. And that's kind of what leads us to this entire episode today, because so many of you have asked that. How do we decide if the FBI investigates or the local DA, the local state bureau of investigation investigates? And then if they investigate, who prosecutes? All great questions. Well, they are two separate sovereigns, the federal and the state. So both, if they have jurisdiction, can investigate. But that seems like a lot of wasted prosecution power and also investigation power. So oftentimes, best case scenario, the state and the feds do try to work together to decide who has the jurisdiction or who is better situated to prosecute that particular crime. But both can actually prosecute the same nucleus of facts under either sovereign. And we do see that sometimes. Some of you have said, this sounds like, a second bite of the apple. It's not a second bite of the apple because they are technically two different sovereigns and they are investigating or they're prosecuting under two separate statutes. And there's not an issue of double jeopardy when the state prosecutes, say, after the federal, or the federal prosecutes after the state. But in an effort to not have competing prosecutions, because you can imagine if the state and the feds charge at the same time, who gets whom first? There is an effort to only prosecute the crime at one time. So one will kind of stand in abeyance until the other is finished.
And there's a lot of working back and forth between the various agencies and the various law enforcement. You've all heard these cases where there's sort of, there's competition and there's turf wars and all that stuff. And that does happen. But the day-to-day operation, day-to-day ordinary crimes, there's a lot of working together and figuring out who has the bigger interest and who can do more. So for instance, I'll give you an example. We talk about felon in possession of a firearm all the time. So imagine you're in a state that says someone who commits a violent crime can't possess a firearm. That's state law. Well, federal law is if you're a felon of any kind, you can't possess a firearm. So federal law is actually broader than a lot of state laws. So you might have a state, they pick up a guy, and there's a lot of Al Capone situations out there, guys. And this is something you have to watch out for. When you see statistics about over incarceration and people who are, in prison for nonviolent felonies, sometimes, maybe even a lot of times, those nonviolent felonies are a way to get violent people off the streets in a more effective way. So felon in possession of a firearm is one of them. That's a nonviolent crime. You just have a gun. You didn't have to shoot it or anything. You just have it. Well, a lot of times, the very worst people end up going to prison because they have the gun, because it's a lot easier to prove that than all the stuff they've been doing with the gun, right? So anyways, imagine a situation where somebody gets picked up. State can't really charge them with that because they don't have any violent felonies in their past. They just have maybe a bunch of drug crimes, but no violent felonies. And so really all they can get them on is maybe possession without a permit, some very low misdemeanor. A lot of times they're going to say to the federal government, hey, y'all take this one. Y'all are much better situated to deal with this than we are. We got plenty of stuff to do anyways. Y'all go ahead and take it.
In that situation as well, because the state would only be able to prosecute a misdemeanor, that guy probably would just do time served and be right back out on the street doing something violent. But with felon in possession of a firearm, the federal statute has a much higher sentencing guideline, and it's much more likely the person will be taken off the streets and therefore prevented from doing additional violent crimes for a longer period of time than if the state just prosecuted a misdemeanor. And also remember, the federal system has done away with parole. And so when you are sentenced in the federal system, you're going to serve almost all of that. There's some exceptions to that, but you're not going to get off early. Whereas in the state system, because of overcrowding, because the state does have a kind of larger general police power and they're prosecuting so many more crimes, that there's going to be kind of greater issues with being able to house all of those who need to be incarcerated, whereas the feds have federal institutions all over the country. So if like the state of Georgia didn't have enough room in a federal prison, they can send them to another federal prison anywhere in the United States. The states can't quite do that. They have to be limited to the prisons that are in their state lines. And so the states still, for the most part, still have parole. And so that's why you see so many people get sentenced to 20 years and serve 3 years and get out. Federal, no. If you're sentenced to 20 years, you're going to serve just about 20 years. And so it's a much bigger hammer and a much more effective hammer at keeping those violent criminals off the streets. And so there you see kind of the back and forth of the jurisdictions talking to each other and deciding who is better situated to take that violent criminal off the street.
And, you know, they really do work together. And a good example of this that everybody knows, the Murdaugh case. So the Murdaugh case, you have a guy who has committed a lot of crimes, federal and state. And the feds had already prosecuted one of his buddies on federal crimes. But they didn't charge him with any federal crimes. They let the state go ahead and do their thing. The state had him on double murder, obviously worse. They let the state go ahead and prosecute that. They got their conviction. And then recently, I think last week, as a matter of fact, the feds came out and they charged him with a whole bunch of federal crimes. Obviously, in charge with murder, because there is no federal murder statute, but they charge him with a bunch of federal wire fraud, bank fraud, all those kind of charges. There probably were state charges that he could have been charged with there as well. And in fact, he has been charged with some things. But there's very clearly sort of a divide going on here where the state's charging him with certain things, the feds are charging him with other things. People asked about where he's going to serve his time. Generally speaking, once you're in the custody of one sovereign, you serve your time with that sovereign. And then if you've been convicted of something else somewhere else, when your time with them is up, you don't get out. You get transferred into the custody of the other side to then serve your time with that. And there can be some sort of, you know, some of your time that's served in federal prison might count towards your state sentence and vice versa, depending on what you've been charged with. Probably not going to happen for Alec Murdaugh. But imagine this happened. He's got his murder charges, which he's got life for that. So he's going to serve the rest of his life in state. But imagine he got off. And then the state, he pled guilty to some financial counts in the state. And he pled guilty to some financial counts in federal prison. And say he got 10 years in the state and 20 years in the federal prison. Well, that 10 years in the state, because they're both for financial crimes, probably what the judges are going to do is they're going to run those concurrently, which means the time runs at the same time. So while he's spending those 10 years in state court, that's actually counting towards his federal time as well. And these are all complicated things that go into sentencing. It's a little sort of beyond what we're talking about now, but just know there is, once again, going to this whole give and take and fairness and the fact that we recognize there are these two different sovereigns basically charging you for the same conduct. I mean, that's the thing. That's why it's, you know, you might think that's not fair. Why does he get time off? It's because it's basically the same conduct that's causing both state law violations and federal law violations. And we have these whole policies where we try not to do that. We try really not to charge people with a state crime and a federal crime. Not because we can't, but just because it seems unfair. And so a lot of times, if the state says, look, we know you guys got your felon in possession. We're going to go ahead and charge him. The state doing that, the feds might say, okay, fine, you do that. We're not going to. We're not going to do it. We're going to pass on our option. Now, once again, they don't have to do that. That's not double jeopardy. This is really important. Double jeopardy applies to a single sovereign. So if the state charges you with murder and you're acquitted, the state can never charge you again. But if for some reason the feds have a hook, imagine, for instance, you're in the military and you kill someone on a military base. The state where that military base is might want to charge you with murder, and the feds might say, go ahead. If they charge you with murder and they lose, the feds might say, well, sorry, guys, now we're going to charge you too. And then they go ahead and do it. And if that seems weird to you, remember this dual sovereignty thing. Think of it in terms of countries. Imagine there's an American standing on the Canadian border and he shoots across the Canadian border and kills a Canadian citizen. both Canada and the United States could charge him for that murder. The United States because he's standing in the United States when he does it, Canada because he killed a Canadian citizen. And say the United States charges him first and it goes, and some American jury is like, whatever, we don't care about Canadians. Their bacon's terrible. Whatever, not guilty. Well, it's not as if Canada has to say, well, shoot, that's terrible. I guess we can't vindicate our Canadian citizen now because some American jury said not guilty. No, they can charge him too. And that feels obvious, I think, to everybody. Well, it works the same way with the states. The states are equal power when it comes to this stuff as the federal government when it comes to charging someone with a crime. The bottom line here, when you're out there wondering how this works, is it's a collaborative process. The federal government and the state government, they're working together. They're not at odds. They're figuring out who has the bandwidth, who has the resources, who has the bigger interest, who has the bigger hammer, who can do more justice to this person.
And sometimes you're working in tandem, like we've talked about, where one will stand back just in case for some reason we've got to get this person. So maybe the feds hang back as that hammer in case something goes awry with the state case. They're ready to swoop in so that you don't both go at the same time. Maybe you can learn from each other. If an entire state trial has happened and there's been an acquittal or a mistrial or something, you have the benefit as well to see what the other jurisdiction has come up with, and the defense had to present everything that they were going to present for their defense there as well. Or sometimes you'll have defendants who know that there's a federal hammer out there with maybe a much more stringent or a much more lengthy sentence available to them than at the state. They may want to plead guilty, knowing that the juice may not be worth the squeeze for the feds to then come after them again. And so talking about the kind of cooperation among the jurisdictions, oftentimes when we are trying to resolve cases, we'll speak to the other jurisdictions that have an interest and say, even though they are not a party to a plea agreement or anything like that, we'll just make sure that whatever deal we're cutting the defendant, everyone who has an interest is okay with it, just out of the spirit of collaboration. Because, of course, the other jurisdiction could then swoop in and say, you know what, that guy deserved way more than 5 years for what he's done. And we know that we could get him for 35 years. We're gonna go ahead and indict him anyways. We kind of want to save those resources. There are way more crimes, guys, than any jurisdiction has the resources for. And so that's just an example of the collaboration where another jurisdiction may have no actual say in a plea agreement or a plea negotiation, but one jurisdiction will just make sure the other jurisdiction is okay with it before signing off on it.
Yeah, so when you ask, how do you determine whether a case goes state or federal, the answer is there's no easy answer. It's complicated. There's a lot that goes into it. Occasionally, you don't have overlapping statutes. Murder is an obvious one. If it's not a murder of a federal official, if it's not a murder that takes place in some sort of federal context, like a violation of your civil rights, if you walk into a church and you shoot somebody, that's probably going to be federal murder because you're violating that person's right to freedom of religion. And so that's a federal hook. But ordinarily, if you kill somebody, it's going to be a state crime. But other than murder and a few other things, usually there is going to be some overlap between the jurisdictions, and they just have to work it out. So at the end of the day, it's just the various people working together. And look, I know it feels like sort of big bad Washington and then whatever's happening in the states, but in reality, there are federal offices in every state. And those federal offices are staffed by people who live in the community. So there's not as much sort of maybe rivalry as you might think. In reality, there's a lot more cooperation. And that's why the system works pretty well. And frankly, you don't really notice this as much as you might think. It doesn't really come up because usually there's not any problems.
So, hope you guys have enjoyed this tour through history with Brett. There's so much there, and we've tried to kind of consolidate all of it so that you have an understanding of why we've arrived to where we are today. What seemed like a simple question, who prosecutes a case, the feds or the states, actually takes a really interesting ride through our entire nation's history. So, if you want to learn more, you should go read history. It's a really interesting topic.
Alice is really on top of things today, I can tell you.
I am so on top of things. But Brett, before I say another thing that, shows how tired I am, do you have anything else to add before we sign off for the day?
I would just say I love all this stuff. I love constitutional law and constitutional history and the development thereof. So if you got any questions about any of that, I am happy to talk about it. So let us know. We're always looking for topics. This was a question that was asked of us, and that's why we're answering it. So if you are interested in any of these questions, we are happy to discuss them in a future episode.
Absolutely. Well, thank you guys for being so supportive of this podcast, of our other podcast, the Prosecutors Podcast, and for all of your amazing comments and discussion by email, on Twitter at ProsecutorsPod, on Instagram, on Facebook. We really do take the time and we love reading your thoughts, so keep them coming. And until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutors Legal Briefs. My brain's not really working. What else do we want to talk about? I can't believe oh gosh.
You're doing great, Alice. You're doing great.
I'm not.
I think.
Yeah. What else do we need to talk about? And until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutors Legal Briefs. Let's try that one more time. And this is the Prosecutors Legal Briefs.
You know what's funny, Alice? You never say, and we are the prosecutors. The only thing you ever say is, this is the Prosecutors Legal Briefs. So I think it sounds funny that you like.